All right, good morning. It's Wednesday, February 7th, and this is Senate Health and Welfare. This morning, we're going to hear some testimony on S-192 and then we're going to go through S-192 with intent of some markup on the bill. And then we will look at S-197 and S-109. Hopefully we'll get to a vote on S-109. So we're going to start with Jack McCullough. And just FYI, for folks who are testifying, we're looking for some brief testimony. I know that some of you have asked to testify and couldn't make it another day, but we're trying to move through the bill. It's been going on for quite a bit. Yeah.
And you wanted me before you hear from Katie about the
Yes, we have language changes that are in the bill that we went through last time, and then Katie edited, improved a couple more changes, and it's been on our webpage, so it's there. All right.
Okay.
Welcome.
Thank you. Good morning.
Good to see you.
Good morning.
Good to see you. I'm Jack McCullough. I'm an attorney with Vermont Legal Aid, and I'm the director of our Mental Health Law Project. And in our work at the Mental Health Law Project, we represent everybody who has an involuntary mental health proceeding in the state of Vermont, including people who've been found incompetent to stand trial or not guilty by reason of insanity in a criminal case in their subsequent hospitalization proceedings, whether those people are found incompetent because of mental illness or because of an intellectual disability. I know the chair. I also worked as a member of the forensic working group, submitted its report about a year ago, and I'll get you my comments to that report. And I've been working on comments. I will get them to you in writing.
Thank you.
I know the chair would like me to be brief. I'll try to do that. But whenever I come here, I decided that one of the things I need to say is that the most important step that the legislature could take to improve the mental health system, to serve the members of the public, and to serve the clients, and to serve public safety is to greatly improve and expand the community mental health system. And everything that happens, that every problem is in the mental health system is either driven or made worse by the fact that the community mental health system is grossly understaffed and underfunded. And we have clients all over the state who are not getting the services that they need. And it's my sense that it's gotten worse since the pandemic. And I think you all know and have heard from other people that every mental health agency in the state has hundreds or more vacancies. And those are people who are supposed to be serving clients, and they're not able to do that. It's my sense that before the pandemic, case managers and staff people in the mental health agencies spent a lot of time physically interacting with their clients, with our clients, and going shopping with them, doing a lot of activities of daily living and helping them manage their lives. And it's my impression that most of that is now just phone calls, and they lose track of people, and people lose track of their treatment relationships, and circumstances decline because of that. Yes.
Thank you. Would you mind giving us some examples of what a community, what some of who the members are of the community health system? Is it as it is in relation to mental health, it would be really helpful for us just to set that.
Sure.
table.
So it's like Howard Center, here in, Montpelier, it's Washington County Mental Health. And I think there are 10 agencies, around the state, and every county is served by, one of those agencies. So
And would you
in
put-
Orange County, Clara Martin Center, and there's another agency that's not geographic, Pathways Vermont, which covers people all over the state. And I think they're called a specialized agency as opposed to a designated agency, but they provide the same kind of services.
Great, and the in-home care systems that we have are also part of this?
Without being exactly sure what you mean, I'm not sure.
What are they called when there are folks who are living, residential?
Some people could live at home. We also have a residential facility for folks that are like a step-down services where people live,
Right,
who have mental
Yeah.
health, like in Westford. there's
yes,
one.
and in Burlington.
Yeah.
In Burlington and Montpelier, there's a number of places like on St. Paul Street,
Right.
Berry Street.
Exactly.
if
Those are
you're-
all part of this
There's
community.
a part of the
health
system, yeah.
Okay, great.
And
So
shortage of
what's
housing.
important probably is to understand that when the hospital closed, and even before that, back in the 80s and 90s, there was a real effort to take people out of institutional care and move them into the community for the care that they needed.
Right.
So Trinity College actually started the first community mental health program in the state. Now it's in New Hampshire
Yeah,
and DTC, or BSC.
but just to distinguish, it's the community health center as opposed to hospital care?
Yes, exactly.
Thank you.
Because you have people hospitalized at, around the state, at UVM, at the Vermont Psychiatric Care Hospital, Rutland Regional Medical Center, Brattleboro Retreat, Central Vermont Hospital sometimes has some involuntary patients. And so it's, some of the people that we represent are stuck in hospitals because they don't have a place to go. And some of the people we represent wind up admitted to the hospital because their services are not adequate. And we really, it's not just staffing, it's also housing. You know, we had,
We haven't heard that one before.
exactly, right. You know, in Montpelier, of course, we're trying to address the problem of lack of housing, and but it's all across the state, and you know that. Senator Reed, did you have a question?
No, I had a question. You said the hospital, you're talking about the Waterbury facility?
Yeah.
Yeah, we just heard from, CFO of Rutland Regional Medical Center. They got a patient that's been there 163 days, tying up in bed because they have no place to go, and they have real issues. And I'm thinking that, we need a forensic facility.
Yeah.
Well, there's a question that gets right into what we're talking about today. And in my judgment, the circumstances we see do not justify creating a separate forensic facility for a couple of reasons. One is that the involuntary inpatient system we have now and outpatient system has essentially two factors they need to, the courts and the system need to decide. One is, does the person require some form of involuntary treatment, whether it's inpatient or outpatient? And then two, what level of treatment does the person need based on what their clinical treatment needs are and on what potential risk they pose to the public? And those factors are considered regardless of whether the person was admitted through the civil system or the criminal system. And it makes no sense to me to throw that over and decide that we're going to assign a certain category of patients to what we're calling a forensic facility, or what I would suggest we're putting them in the hospital and pretending that it's not a hospital, or part of it's not a hospital. But the reason that they require a restricted setting is not because they were charged with a crime, it's because they were determined to have done something dangerous. And you could be hospitalized through the civil commitment process under Title 18 because you've done something dangerous, even if you were never charged with a crime. And so a lot of our clients wind up being hospitalized because they assaulted somebody, or they did any number of dangerous things. And it's kind of arbitrary whether they got charged with the crime and went in through the criminal system, or they got picked up through the emergency Title 18 process and wound up being committed into family division. But either way, the determination is what kind of treatment and what kind of confinement they require. And I think that the creating something separate as a forensic facility is arbitrary. Center.
Is that your testimony?
Almost.
Okay.
I just have a question. Thank you. The chair,
Yeah.
just wanting to make sure he knows that you're the one that calls on people, not him. My question is, so if people are hospitalized or institutionalized in some way through the Title 18 process, where do they go? If we don't have a forensic facility, where do people go?
Well, there are a couple of things. One is that you can be initially committed to the hospital for a period of 90 days. If you wind up getting treated to the point where you no longer require treatment in a hospital, then you can be out of the hospital on what's called an order of non-hospitalization, or an ONH. And that's a order that still puts you in the custody of the Department of Mental Health, and requires you to accept treatment, but it says you don't need to be in the hospital. And so where could that be? It could be anyone from a person's own apartment to some kind of group home setting, to the place that used to be Middlesex and is now called River Valley up in Essex, which is, as far as I can tell, I don't see what the difference is going to be between the forensic unit at DPCH and what we already have at River Valley. And River Valley was established and funded and constructed to have 16 beds. My understanding is that they're nowhere near 16 beds now because
So
they
I
can't
think we
find
need to
staffing.
move on. I hear what you're saying, and we're getting a drift of where we need to be on the testimony, so. And I understand it's helpful, but.
If I may just check to see if there's anything I haven't hit, but so at any rate, since we already have River Valley, it's not clear to me why we need to do anything at DPCH. And for that, why they're even proposing DPCH is the place to go. There are people who are hospitalized at the Brattleboro Retreat, hours away from where they live, who could be hospitalized at DPCH and probably be better for them. I will
So will you get us
follow
your
this up with,
testimony
I'll supplement
and
this.
writing, and you've heard some of the questions, just sort of basic questions. You want to ask for that information? That's always helpful.
Great, I'll do that.
Yeah.
Thank you.
Good, thank you. And Mary Graham McDowell, I think, is up on the screen. Welcome. Thank you for being here. Why don't we just go around the table briefly so that folks who are new to us know who we are. We'll start with Senator Hardy.
Thank you. Good morning. I'm Senator Hardy, Ruth Hardy from the Addison District.
I'm Senator Terry Williams from Rutland District.
Ginny Lyons, Chittenden Southeast.
Good morning, Dave Weeks from representing the Rutland Council.
Martine LaRock Hewlett, eating pecan pie, from the Chittenden Central District. Good morning.
Good morning. So why don't you introduce yourself for the record, and then we will listen to your testimony. And if you have your, please send your testimony in writing as well. That would be helpful. Thank you.
Well, good morning. I'm in good company. I'm from Rutland County. I'm Mary Graham McDowell. I'm the Director of Developmental Services at Community Care Network, which is one of the designated agencies for the state, in the state of Vermont. I have worked for about 25 years in both mental health and developmental services, and also was a member of the work group, the 192 work group. Should I keep going?
Go right ahead.
Okay.
Right.
Okay. I will try to keep this brief. I have paid attention to all the previous testimony, and I think there have been some great questions. I prepared to fill in some gaps. Senator Hardy, you had asked some really strong questions previously, so I'm going to try to address a couple of those. I'm also available to answer any questions. I do oversee a staff of about 85, and we are providing the direct on-the-ground services to those that we're talking about today. So first, just as a general statement, I have 3 points, basically. The first is a general statement that I would like the committee to understand that the community supports that are suggested for folks with developmental services for this specific very small population. So again, we're talking about, in 25 years, I have probably known 2 people that I would ever think would be a good candidate for this forensic facility. If they do not have access to a forensic facility and we are asked to provide the community support services, these community support programs are extremely isolating. So they're gated alarms, often very restrictive. People might not be safe to transport. So sometimes there's a consideration for purchasing old police vehicles to drive people around. They're just very isolating. And I just wanted from being on the ground, I wanted people to understand that. The other piece of the general statement is just that sorry, I had a ding in my, that the people with intellectual disability who access the developmental services system cannot also access the intensive mental health supports that they often need. So the 2 systems do not work simultaneously. For this very small group of people, if they receive intensive developmental services programming, they can't access mental health supports intensively as well. And often that's exactly what they need. So I wanted to make that general statement that with the forensic facility, this small set of people or 1 person with IDD could also have the opportunity to receive intensive mental health treatment, and that's very important. And it's a gap. It's definitely a gap. So that was the general statement. Then I just wanted to make 2 points. Senator Hardy, you had asked a really good question last time about combining the populations of mental health and developmental, whether that would work or not work, or that was a concern you had. I do not see difficulty to this question in sharing the resources, staff, and space in the facility. They're not mutually exclusive populations, and that the people that would access this facility could actually have a peer group. They could have a less isolating opportunity than the community program that they would access without having gone to the facility first. I think that there are 2 parts that are very important in considering these populations together. One is proper screening. for people going into the forensic facility, and the other is oversight of the facility as a whole. The work group was unanimously in favor and made some strong recommendations in their report about creating the oversight of the facility so that we can have people that specialize in this work and in populations like IDD to be able to ensure that proper care is provided. And the work group also put recommendations in the report that I would draw your attention to around the proper screening for people to enter the facility. So I think with proper screening and the ongoing dialogue and oversight of the facility, I don't see an issue combining the populations. I also thought that I would give an illustration of that point. So an example of an example of someone that may, this is a hypothetical, but a person that's pretty realistic, a person that would be a candidate to access this facility. So let's take someone that is considered for the forensic facility who has autism level 3. So that would be a very involved, the autism would be inhibiting the quality of life for that person. And they, because of the autism, have a very hard time accessing their community and a quality of life. They may not be screened as a good candidate for the forensic facility. So in that circumstance, we actually do specialize and create some really robust, good programming for people like that in the community. On the other hand, someone may have a moderate intellectual disability. In all other accounts, they want to live independently. They can live independently. They can take care of their daily needs, but they may have committed a crime, an egregious crime, and would be a good candidate for the facility. I do trust that the screening for this facility will be done well, and therefore the people at the facility would be able to be together. So the person who had moderate intellectual disability might also have a significant history of trauma, and that's exactly the kind of person that could receive the treatment they need in the facility. So I wanted to give an illustration of that. I thought that you asked good questions, Senator Hardy, and I hope that that helps illustrate that point. Again, I guess just in closing, I would just suggest that there are 2 sections in the work group's report around the clinical programming and the screening that I think are very valuable to consider. So I'll pause there, and I think that that's the end of my testimony unless there are questions.
Terrific, and thank you. And I think if we have your testimony in writing, that would be very helpful. Senator Gulick has a question, and then Senator Hardy has a question.
Thank you, Chair. Thank you for your testimony. I'm wondering, I believe you said you've seen only 2 people in about 20 years who fit the category that we're discussing. So I'm wondering if you can comment on the need for a 9-bed facility.
Some of those
well, I'm only one agency, so I think if you took the other agencies we were mentioning, that 10, let's say 5 of the 10 had somebody right now, there's a chance. I guess we would need to ask the other agencies, but I don't think that we wouldn't fill 9 beds would be my assumption. I agreed with Stuart Schuer. I think we would, we would probably use 1 to 4 statewide.
Thank you.
Yes.
Right, and one of the other considerations that we don't talk about is that some of these folks who've committed the egregious crimes could end up in jail where they have no support. And so the alternative from the secure facility is a little bit concerning. Anyway, I'm sorry, you were gonna ask.
That's okay. Thank you, Mary. I appreciate, excuse me, I appreciate you trying to answer my questions. But the way you describe it, it sounds like a very neat and friendly kind of clinical referral to a facility, when in fact what this is a court making a decision, a judge making a decision about where to send somebody who's committed a crime, who has, either severe mental health or severe developmental disabilities. So, or intellectual disabilities. So it's not as warm and fuzzy as you make it sound, I guess. So I'm a little, your testimony made me feel a little bit better, but I still have the concern that this is not a warm and fuzzy situation. This is very much the opposite, and that these are extreme and difficult situations that are put together in a facility that may not have the capacity to meet the very difficult needs. It seems to me that I can understand the argument for needing a forensic facility, but it seems to me that it might be two different kinds of facilities. Although the complexity with that is that if we're really talking about 1 or 2 people every 10 years, then that also, the numbers don't justify that. So I don't know if you have more to say about that, but it's not as friendly, or I can't quite figure out the right word as you described it.
Yeah, I think I would just comment that I find the judicial system very open and wanting to hear clinical opinions. At least in Rutland County, we've been asked, and I feel like people really want to know what the providers and what the people around that are wrapped around someone that would be considered. I think that the court system does want to know what the recommendations would be. So yes, you're right. And I would be remiss if I made it sound too warm and fuzzy. I agree with you. It is a very stressful, tenuous system. And I do think that we have an opportunity here to provide input, and that usually is considered when the courts are making determinations.
Yeah, so as I indicated earlier, it's better for the court to have this kind of information than to the alternative of going to jail only, and that's the biggest concern. Karen Barber had her hand up. Did you want to weigh in on this question? Answer?
Yeah, if I could, I just wanted to kind of clarify. So the court ultimately makes the decision, but the court on its own can't just place someone in the forensic facility. It would be that the commissioner, either of DMH or Dale, is saying, we believe this is an appropriate clinical placement and we believe this is the least restrictive. And then what the court is deciding is, yes, we believe this is the least restrictive, or no, it's not the least restrictive. But it's the commissioner that's making a clinical decision first about whether or not to apply to the court to say the forensic facility is appropriate. So I just wanted to make sure that was really clear, that that clinical threshold has to be met first, and that that's a decision made by a commissioner.
Thank you. Okay. All right. Any other questions for Mary? Thank you for being available, and we look forward to having your written testimony, and don't leave your job anytime soon.
Thanks, John.
Thank you. Terrific. So we have Marie Lallier also up on screen. So thank you for being here. We've introduced ourselves already, and I think you know who we are. So we're going to just have you go right ahead with your testimony. And we have all your testimony here, so that's helpful. Thank you.
Great. Thank you for having me. My name is Marie Lallier. I'm Developmental Disability Services Director for Vermont Care Partners, which supports all of the designated and specialized agencies in the state. So I thought I would just follow on Mary Graham and kind of give a little bit more of a provider perspective. 2 major points that we have come to looking back the last couple of years. There was a lot of anecdotal information about people with IDD in crisis in the community. So we've worked really hard the last couple of years to pull together some data so we can really understand the picture and make some decisions, knowledge-based decisions from there. two,
So, I'm gonna ask you, Marie, as you're speaking quite rapidly.
okay,
And the words are not coming through as clearly. It's the Zoom issue. So,
okay,
that's all. If you
it
could
might be
just
my
speak.
connection.
No, it's good. Now it's good. Go ahead.
Okay, I'll slow down.
Terrific.
So two major themes that have emerged are IDD informed healthcare, particularly IDD informed mental health care. And you'll see in the survey results, there was space left open for stories for staff to illustrate the barriers to people with IDD getting accessing mental health care. So that would be something that we would really want to see considered in developing the forensic facility details, is that, clinicians, administrative that are, are IDD informed, are willing to understand some of the issues and provide accommodations. And that's across the board. That is in community mental health care, community health care as well. The other major issue or theme that emerged is the spectrum or the continuum of services in the community. And as you all know, the system is really under really serious strain. So we are looking at crisis or less restrictive crisis related options in the community that can be built up and kind of strengthen that system. We're working internally, and we will be working with community partners and DDSD. So, and while considering those, also taking a hard look at staffing and housing, which are major barriers as well. So kind of wanted to put that out there, that the VCP position, the provider position for programs and agencies that provide services to people with developmental disabilities, is in support of the bill, but with conditions, and one of them being, IDD informed healthcare, and that we take a closer look at what's available, what is community based, what are the less restrictive settings, because there really are ways to help someone stabilize and stay in their community. So that's a very brief update. I hope I didn't break up too much, and happy to take any questions.
No, that was terrific. Thank you. And all the information that you sent is very instructive. Appreciate it a lot. So Senator Hardy has a question.
Thank you, Madam Chair. Thank you, Marie. I haven't had a chance to look at your written testimony yet, but did you have specific language suggestions for the bill that would do what you're recommending? Where we could insert your recommendations to make sure that they're following the protocols you'd like?
I don't have it handy, but we can provide that or suggestions. And there's also, there were suggestions made by a clinician who participated in the work group last fall. So we can share that as well.
Yeah, I think that would be helpful, especially, Vermont Care Partners is a statewide organization that works with individuals with both developmental or intellectual disabilities and some mental health. So I would appreciate seeing any specific language suggestions your organization might have to make sure we're embedding it in the process.
Sure.
So and then a caveat to that is that the number of the comments and suggestions were made during working group. So, and some of it is already in here, so it'd be helpful to know. We'll have to look and see what it deviates from the recommendations of the working group and consider that. But I agree with Senator Hardy. Send along, your comments. That'd be useful. Thank
Happy to.
you.
Thank you.
All right. But please don't ask us for millions of dollars for new community-based resources. It's not
We're
our
not
job. And
there yet.
we completely agree with the need that's out there. I couldn't agree more. It's just, it's a never-ending need. Yeah. Other questions? All right. Thank you so much for being available and for your work. Appreciate it very much.
Thank you all.
Okay, so, and now we can move along to the bill with Katie, and she's put a new, slightly new. Draft 5.1, it doesn't feel like that, but there it is.
Good morning.
Good morning.
Katie McLean, Office of Legislative Counsel.
It is, we already have another draft. We didn't even talk about what we wanted in another draft yet.
No, Katie will explain what the yellow is. It's not anything, it's her edits to improve the language. We haven't talked about the draft earlier, and that's still this draft with Katie's yellow. So can you explain what is new in here that the committee did not look at previously, but is now here today?
Sure. So I just pulled up draft 5.1. Draft 4.1 had previously been posted. That was changes made at the direction of the chair, and then 5.1, I found an error last night and I fixed it. All the changes are highlighted in yellow, and I can walk you through them.
Okay. And we had in there, remember, we had talked about adding H89 language from the House Judiciary Committee, and then the organizational structure that Katie had put in that made the bill a lot more readable.
Right. So that language is all still in there because it's no longer new. I took the highlighting off of those sections so that you could sort of find what's new in this draft. I still have the brackets of the to identify the language from House Judiciary. So if there's a point where you want to stop having that identified, I can remove that. Okay. So the first change is in the mental health part of the bill.
And let's do this. Let's go through the changes, and then let's go through the bill and look at where the brackets are and the decision points that we need to make as a committee.
Okay.
Yeah.
Okay. So dating. I know it's first change is almost halfway into the draft. Okay, thanks for your patience. So the first change is on page 16. Yeah. So I'll scroll back up to show you that we're in the section of the bill that is applicable to individuals who are in the custody of DMH. And if you remember the conversation, there's a judicial process whereby the commissioner can submit an application for involuntary medication. And we talked about how there was a list of the circumstances in which the commissioner could seek involuntary medication. This draft has proposed that the forensic facility, somebody committed to the forensic facility, be a place where involuntary medication can be requested if certain criteria are met. And this draft adds to that a person who is at the secure residential recovery facility. So what had been Middlesex and is now in Essex Junction. So that is the first change. The next changes are in the part of the bill pertaining to individuals with intellectual disability. This is the language that we restructured and went through last time. So I am scrolling down almost the very end. What was that?
Page 32.
Thank you. I'm probably making the people following along at Zoom car sick.
Talk about vertigo.
I know, sorry. So this section 8847 was how a person is discharged. And when I was walking through it with you last week and I got to this paragraph D, as I was walking through it, it sort of dawned on me that the language in this particular subsection was about placement in a forensic facility, and that it really was about person being discharged from commitment and not about their specific placement in the forensic facility. So all of these changes are trying to correct what I feel like was a mistake. So this language would read that whenever a person is subject to a judicial or administrative discharge from commitment, the criminal division of the Superior Court shall retain jurisdiction over the person's underlying charge, and any orders holding the person without bail or concerning bail and conditions of release shall remain in place. Those orders shall be placed on hold while a person is in the custody, care, and habilitation of the commissioner. When the person is discharged from the commissioner's custody, care, and habilitation to a correctional facility, the custody of the commissioner, meaning Commissioner of Dale, shall cease when the person enters the correctional facility. So it seemed to make more sense that this was about commitment itself and not about placement in a facility. So I made that change. Then there's a new section 14 added with regard to the competency examination. So you probably remember better than I do last year, you worked on this bill with Eric, and there was, and it was who could do the competency evaluation, and the committee said that it could be conducted by a doctoral level psychologist, but you put a sunset date in, and so this removes the sunset date, so they would continue to be able to do that evaluation.
And we have a letter from the Judicial Oversight Committee, and we met, members of the Health and Welfare Committee met with that committee for a couple of meetings and came to the conclusion that the sunset should be removed. There, we can post the letter, I think we still have it, and we'll post that letter.
Wait, did we meet with them, this committee?
No, but 2 members of the committee, 3 members of the committee did. I'm on that, and then I think Senator Weeks and Senator Gulick also met, were appointed by the Committee on Committees to meet with the Judicial Oversight Committee for, I don't know how many meetings was it? 4 meetings, yeah, where we took testimony and analyzed this. That was a direction in the legislation that we passed, that we get a recommendation from the Justice Oversight Committee.
Wait, are you on the Justice Oversight Committee? I'm confused.
No, they were appointed to
Just
meet
as, like,
up to,
separate.
they were appointed to meet up to 6 times, and we only met 4 times, and to make a recommendation about this.
Okay.
So I asked Katie to put it in, based on the letter that we received from the Justice Oversight Committee.
Okay. And then there's a new section 15, and this is seeking a fiscal estimate for what the competency restoration program that's been discussed would look like. So by November 1st of this year, it asks or directs AHS to submit a report to various appropriations and subject matter committees. And the report would provide a fiscal estimate for the implementation of a competency restoration program that's operated or under contract with the Department of Mental Health. The estimate would include varying options that are dependent upon which underlying charges are eligible for court-ordered competency restoration. And the report also include costs associated with establishing a residential program where court-ordered competency restoration programming may be performed on an individual who is not committed to the custody of the Commissioner of Mental Health or of Dale. And then we have renumbering for the remainder of our sections. So those are the changes from the last time you've seen.
The cost analysis.
Did I miss something?
No?
No.
I don't think so. Okay, all right, so those are the new things that are in. My suggestion is that we go through and look at the new things that were placed last time. So for example, the stuff in brackets,
Okay,
Can you identify for us, or maybe we should put that other draft up
sure, I could do that.
and look at that other draft that already has the, identified language, because I think might be some decision-making points, but you've already put some in there. You're the expert on where things have gone, so.
I'm trying to find the old draft. So it would have been 3.1, because anyone's finding it faster than me.
Is it 4.1?
No, it would have been 3.1.
We skipped 4.1.
4.1, no, it wasn't skipped, it was even posted, but then I made that change that I found when I was, the error I corrected that we just watched through in subsection D, I corrected that.
Oh,
So
so
that
that
is
made
the difference
4.1.
between 4 and 5.
It's hard to keep track of these drafts, and it doesn't feel like we're talking about the changes before they get in there, so that's,
No, the only changes
Concerning.
that we haven't seen are the ones that Katie just showed us.
no, I know, it's not about seeing them, it's about deciding that's what we want as a committee, thank you.
Well, we haven't made any decisions.
But they're in the draft, so that seems like
They are for
decisions have been made.
decision-making.
So draft 3.1 is posted on February 1st.
Thank you.
Yeah, pull it up.
And that's the one that we looked at together last week.
Yes.
So we can pull that one up.
So I'm gonna, again, scroll through this. A lot of the highlighting you're seeing here has to do with cross-references to forensic facility and all of the different titles in which we're using forensic facility, so we have the same definition throughout. Most of the changes, oh, here we go. We're in the second half of the bill, which pertains to people with intellectual disability.
What page?
I'm on page 19 right now. So this is language in Title 13, the criminal justice title. I'm gonna go over the language that hasn't been changed because I think looking at all the pieces in context is really helpful. So in subsection A, it recognizes that if a court finds that a person is a person in need of custody, care, and habilitation, which is a defined term in Title 18, that the court is to issue an order of commitment to Dale for placement in a designated program in the least restrictive environment consistent with a person's need for custody, care, and habilitation. And then subsection B, commitment procedures for an order initially issued pursuant to subsection A and for discharge from an order of commitment or continued commitment shall occur in accordance with the sections in 18. So the new sections that we talked about last time that we're about to look at, it's just cross-referencing to say, you know, we're kind of kicking the procedures over to Title 18. So that's where they're located now. In subsection C, in accordance with section 8845, if the commissioner seeks to have a person committed pursuant to this section placed in a forensic facility, the commissioner is to provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendation of the panel. And that panel hasn't changed since we first looked at the bill. And then we move to Title 18 itself. So first we have a definition section. I won't spend a lot of time here since we haven't made too many changes, but this is where the definition of person in need of custody, care, and habilitation and person in need of continued custody, care, and habilitation live. We've added a definition of victim for the time being because some of the language that you were looking at from House Judiciary used the term. So now we have a definition.
Maybe, Katie, what I would suggest is go a little bit slower so that
Sure.
we know that the whole committee can digest what you're saying,
Okay.
because there's a lot here.
I can do that.
That would be good.
Do you want me to pause here for a second for
So, and
questions?
the umbrella is that what we're doing is we're putting intellectual disabilities in with a process that is comparable with mental health, more or less. Can you talk about that again, the umbrella?
Yeah,
piece
I
again?
wouldn't call this draft making the systems
Yeah.
comparable. There
That's the
are,
best word.
I would say that really the work that I've done in this section is to reorganize for clarity, I hope. There are differences in the mental health system. There is an initial petition that is filed with the court to have somebody initially committed. In the Dale context, it's more automatic that if a person is found not competent to stand trial, that a court is going to look. So those are differences. In the mental health context, the initial order is 90 days, and then the continued order is up to a year. In the Dale context, that's not the case. As you saw and have discussed, the language is for, I forget the specific language, but for a limited or indefinite period of time. So the timeframes there are different. And then also we have administrative and judicial discharge procedures. So I wouldn't call them parallel tracks, but they
Organizationally.
but it's reorganized.
Can I ask a question?
Yeah.
So, two things. One, you had I think it was for this bill, Venn diagram. Did you get a chance to make that?
No, that really had to do with the competency restoration piece.
Yes.
Right.
But I can make it for you. Is that what you think?
Well, I mean, I'm trying to figure out things that might be helpful for making sure I understand this bill before, because it keeps changing, which is also challenging. And also, do you have something that lays out the difference between the two processes that you just spoke to? So this is the sort of flow chart for what happens for mental health, and this is the flow chart for what happens for
I have a
intellectual
flow
disability.
chart for mental health. I do not have one for developmental disability, but I could put a flow chart together for you.
Yeah, that might be even more helpful than the Venn diagram. So
Once we get the full bill, that.
whatever you have
yeah.
time for. I don't want to make you do things that are not helpful, but I'm just trying to figure out ways to make sure that I understand the two processes and how they're similar and how they're different, because ultimately they're ending in the same place in this forensic facility. So that I'd like to know how we get there. But I want to understand that better for the two populations, because that's the crux of my concern, is the difference between the two populations.
Okay.
Okay, thank you.
You're welcome.
That would be terrific, and that Venn diagram is different, but that would also be helpful.
Okay.
Wait, you crossed it off.
I crossed it off. It's back on my
Don't
to-do
cross
list.
that.
Okay. Let me think more about how to present that. Okay. I'm gonna keep marching along
Yeah,
here.
keep going. And then when we go back through the entire bill again, some of this will gain clarity.
Okay, so the next several sections are struck through. That is not a change. That was the request from the department, because this language was no longer effective as a language in another subchapter had been repealed several years ago, and they sort of went hand in hand. So this begins where I started all of the reorganization. So 8845 deals with the initial order. And if you remember, it's the criminal division that's making that initial order. So if a person is found incompetent to stand trial, the criminal division shall automatically schedule a hearing. So this is where there's, unlike somebody coming through the Department of Mental Health where there's a petition, this is automatically scheduling a hearing to determine whether the person is a person in need of custody care and rehabilitation and requiring commitment. The commissioner's recommendation that a person be placed in a forensic facility, because commitment and placement in a facility are sort of two different determinations, if applicable, shall be filed with the court in advance of the commitment hearing and shall expressly state the reasons for this determination, that it's clinically appropriate, and programming can be provided safely only in a forensic facility, and also include that Human Services Community Safety Panel recommendation. Then in subsection B, the commissioner or designee shall attend a commitment hearing for custody care and rehabilitation and be available to testify. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. In subsection C, we have which rules of evidence apply, and subsection D.
So just some of this is gonna be looked at in the other room, in judiciary. Most of this is, what happens to people is important to us.
Not in there.
Okay, so this is the order. Subsection D is the court making an order. So they've had the hearing. The court finds by clear and convincing evidence the person is a person in need of custody, care, and rehabilitation. They meet the standard in statute. The court is to order that the person be committed to the commissioner and receive appropriate treatment and programming in a designated program that provides the least restrictive environment consistent with the person's need for custody, care, and rehabilitation. And here's that term on the top of page 26 for an indefinite or limited period. In subsection E, so we just talked about an order for commitment. E is talking about placement in a forensic facility. So if the commissioner has recommended to the court that the person be placed in a forensic facility, the court, after determining that the person is a person in need of custody, care, and rehabilitation, shall determine whether placement at a forensic facility is both appropriate and the least restrictive setting adequate to meet the person's need. If so determined, the court shall order the person placed in a forensic facility for a term not to exceed the duration of the initial commitment order. So however long the commitment order was initially ordered, the placement in a forensic facility can't be longer than that.
It can be less.
As written, it can't be less. Okay. So next is 8846. This is where we have continued custody, care, and rehabilitation. So we have language that at least annually, the commission is to initiate a judicial review in the family division as to whether a person who was initially committed as a person in need of custody, care, and rehabilitation now needs continued custody, care, and rehabilitation, if they should continue to be under the Commissioner of Jail's custody. The commissioner shall, by filing a written petition, commence proceedings for the continued custody, care, and rehabilitation of a person. The person shall include the name and address of the person alleged to need continued custody, care, and rehabilitation, and a statement of the current and relevant facts upon which the person's alleged need for continued custody, care, and rehabilitation is predicated.
Wait, address? Isn't their address the facility that they've been committed to?
Oh, that's an interesting question. I think I pulled this from the mental health statutes.
Okay.
So let me take a look if that is where I got it from and how DMH interprets that when they do their petitions.
Okay, thanks.
Put myself a note. Okay. In subdivision 2, notwithstanding 1 that we just looked at, subdivision 1, a person may initiate a judicial review under this subchapter at any time after 90 days of the initial court order of commitment. So even though the judicial review is automatically initiated at least every year, the person themselves could initiate an earlier review after 90 days. If the commissioner seeks placement for the person alleged to need continued custody, care, and rehabilitation at a forensic facility, the petition for continued custody, care, and rehabilitation expressly states the reasons for this determination, that it's clinically appropriate, including a recommendation of the panel. And you'll see I've recent in parentheses because that was a conversation this committee had, when is the panel doing this review? In subsection B, upon receipt of the petition, the court is to set a date for a hearing, which shall be held in accordance with the evidence and hearing language that was in the previous section. So it's cross-referencing the evidence and hearing provisions. In subsection C, if at the completion of the hearing and consideration of the record, the court finds by clear and convincing evidence that at the time of the hearing, the person is in need of continued custody care and habilitation. Commitment shall continue in a designated program in the least restrictive environment with the person's need for continued custody care and habilitation for an indefinite or limited period.
Keep going, and then I ask a question.
Okay. If the court, on the other hand, finds the opposite, that the person does not need to continue to be in custody, the court is to discharge the person from the custody of the commissioner in accordance with the provisions of the next section. In determining whether a person is a person in need of custody care and rehabilitation, the court looks at the degree to which the person has previously engaged in or complied with treatment and programming provided by the commissioner.
So the question I had was kind of fundamental question. You know that custody care and rehabilitation is a term of art or of Dale. Is there a definition of that somewhere?
Yes.
And do we have it in our bill?
Yes.
Yes, we do. Okay.
It's in the first
I thought we
section
did.
of this subchapter.
Yeah, okay, go ahead. Yeah. Go ahead.
Can I ask a question? On line 2, I think, indefinite or limited period, why is both there? Because it seems like that means anything.
That is what is currently in statute.
Okay, that also, I think, it feels like we need to be more specific there, because that just leaves it so open-ended that.
Well, there's a specific recommendation being made? So that is a question. How does that link with any specific recommendation being made by the commissioner?
This is the term that's currently in statute, which is why I kept it here. It's a policy decision that you could make. If you're uncomfortable with that, you might want to hear from the department as to how this works now and the impact of changing it, and what would be their proposal perhaps for making an adjustment.
It seems to me we would want to say for a specified period, so it's clear how long the person would be in there. If it's indefinite, it could be
Indefinite.
Can you show us the first part of that sentence?
Sure.
Just go up this to here.
I don't know if I can show it all at once.
Are Karen or Stuart still on Zoom? Kiki?
Yes, good morning.
Yes.
Okay, so you're hearing the question. Don't respond just yet. We're still looking at what we need to be asking you, but you're hearing the question.
Yes.
Okay. Thank you. Thanks for being there. Okay.
So the paragraph we have been talking about and discussing, again, is about continued commitment. Somebody has already been under initial order of commitment. The court is looking at whether they should continue to be held. And then in this subdivision 2, we get into the question of where should they be held? So this says that if a petition in which placement at a forensic facility is sought, the court is first making a determination on continued custody. If the court grants that petition for continued custody, next it's going to determine whether placement at a forensic facility is appropriate and the least restrictive setting adequate to meet the person's needs. If so determined, then the court makes that order and the person is placed for a term not to exceed, again, the duration of the order for continued custody.
Wait, where's the not to exceed language?
Line 16 and 17. We're on 2 different pages.
Okay.
So page 28, line 16.
Oh, I see. Oh, you kept going. Oh, I'm sorry.
kept going, yeah.
So this paragraph is about the court having already decided somebody needs continued commitment.
Okay.
And this is a person who the commissioner has filed a petition to have that person placed in a forensic facility.
Mm-hmm.
The court here is making a decision as to whether that placement is appropriate. And if it is appropriate, if the court determines it is appropriate, then they can't order a person in a forensic facility longer than the order for commitment.
Not to exceed the duration of the order. Okay, I see that. But how does this relate to the indefinite or limited period in line 2?
I mean, if it's an indefinite order for commitment, then this would also be very open-ended in terms of placement
Yeah.
at a forensic facility.
Good question.
Yeah, I think I'm just a little concerned that that's so open-ended that I'm worried about somebody just getting stuck there because indefinite is what the order is, and then there's this sort of.
Yeah. So Stuart, do you want to comment on this?
Certainly, thank you. For the record, Stuart Scher, General Counsel for Department of Disabilities, Aging, and Independent Living. Yeah, thank you for that question. The law currently builds in these annual judicial reviews, and commitment orders currently don't have end dates. There's an expectation that this matter will be brought before the family court on or about the 1-year anniversary. So that is how the current framework for commitment currently exists. The expectation is that no one will be stuck in Act 248 and would not be stuck in a forensic facility. They would have the opportunity to go before the family division at least annually, if not sooner, on their own petition. So that's why it's left open-ended. It's always been that way. The orders themselves don't have end dates, and that's one of the major distinctions I think that Katie was mentioning between mental health and intellectual disability.
Okay, I guess
those orders don't expire. In other words, they're open-ended, and then the court looks at them annually to determine whether they should continue, whether that person is a person in need of continued custody care and habilitation. And if they're not, the order ends.
So let me ask this question, Senator Hardy asked us, this is a good conversation. We just got interrupted by some music that we didn't ask for. So the distinction between someone with a mental health issue and someone with an intellectual disability, is there a basic distinction there that we're making and that allows for that language? Or
I wonder if it'd be helpful if I explained how it happens in the DMH world. Okay. So in DMH, there is also that language in there about an indefinite period. However,
Karen,
yes,
please state your name for the record.
Apologies.
And then go slowly because we need to process everything.
Sure. Karen Barber, General Counsel for the Department of Mental Health.
Okay.
So in DMH world, a couple things. One, there's also that indefinite period language. However, there's been case law interpreting that. So it's clear that if it's an order coming out of the criminal court, it can be no more than 90 days. And then in Title 18 in the civil section, it's clear our orders are for a year. So they do expire after a year on the civil side. And so we have the affirmative obligation, if we wish to keep someone in our custody, to re-petition to file an application for continued treatment.
Okay, that's really helpful, Karen. I guess I would like the same.
This is the decision point we have to make.
Yeah, I think that this is too open-ended, and I mean, Stuart's language of there is an expectation that this happens is not comforting to me, Stuart, because that doesn't mean that it absolutely has to happen. There's just an expectation that it will happen. So I think I would feel better if this is like, you cannot commit somebody for longer than a year. And then if you want to, there has to be a review an annual review that has to happen. And then it's much more certain, I think.
I couldn't agree with you more on this. So this is a discussion that we had in the working group, and I think there were members of the working group who wanted to put that recommendation in. And so it's a decision point for us. And so Katie, if you could mark that as a decision point to offer clarity about the initial commitment and then the review process. And Stuart, I'm looking at you and also Karen for your help in that language so that we can make a decision.
Yeah, I'm happy to work with Katie on that language for your review. I don't disagree that there could be some greater clarity to give some assurances that these petitions will be filed annually, and the department wouldn't have any objection to language that would have those orders expire at the 1-year mark, as long as there's an understanding that they remain in effect. If the petition is filed, they remain in effect until such time as the court hears the petition. We wouldn't want there to be a gap where the department files its petition within the 1 year, and for whatever reason, the court isn't able to hear it until the 13th month, for example, after the order. And I'm sure DMH, the language in the mental health statute addresses that, so there is no gap. But that's the concern that we have.
That's helpful. The initial 90-day commitment is also a consideration that we would like to make, I think. So both of those are decision points for us. We haven't made a decision, but they were also critical in our thinking. Well, some people were thinking about it when we went through the working group discussion.
Yeah, and I think that Stuart, in particular, that indefinite or limited period, that's so open-ended that as to be meaningless. So, and maybe that's the way it is in the mental health world, as Karen says, but it seems problematic, and maybe we need to change it in both places if it's.
Okay.
My only response would be that that's the way the statute has been, and it's been working. Some would say maybe that it's not working, but from the department's perspective, that ambiguity hasn't been a problem. We have been filing our petitions more or less within the 1 year. And yes, we maybe, as legal aid said, there have been some situations where there has been some delay in filing those annual judicial review petitions. For the most part, they are done timely, but we have no objection to that. I would say that the working group was talking about the 90-day limitation, not with respect to commitment orders. I could be wrong, but I think they were talking about it exclusively with respect to the duration of a placement order in the forensic facility, being limited to 90 days.
You're absolutely right. You're absolutely right. That's another place.
Yeah.
All right, so take the 90-day thinking out of the commitment order, because that's left, I won't say open, but it may have it.
And if I might just, Stuart, I appreciate that you think it's working, and I'm sure I don't disagree. I don't know enough to dispute that, but I don't have to tell you that words matter, especially when the court is looking at this, and us being as clear as possible in the language, so the court does not look at it and go, well, they're really vague here. It could be anything. So I feel much more comfortable if that language in both cases is more specific.
Okay, well, we're getting to discussion, so we'll move on. We understand it's a decision point. We need to hear from everyone on the committee. And so we'll have Katie and Stuart put their heads together, possibly with Karen, and bring us alternative language.
You want to see new language?
Yes, please. And then alternative language. And then we'll move on from what are we on next?
You want me to pull it back up?
Yeah, we're not done yet. We'll go a few more minutes.
Okay.
What page are we on? We're almost done, so let's try and finish it off, and then we'll take a break, and then we'll come back.
Okay. So this last 8847, this is about discharge. Discharge from both commitment and from placement in a facility. And so subsection A just sort of outlines what the next paragraphs are about. That a person who is committed may be discharged from an order of custody, an order of continued custody, or placement at a forensic facility by the family division after judicial review, or by administrative order of the commissioner. And you'll see that with regard to the family division review, it cross-references subsection B. So in subsection B, this is discharged by the court. A person who's under a commitment order for custody, care, and habilitation, or an order for continued commitment, shall be entitled to a judicial review of the person's need for continued commitment pursuant to the language we looked at in the previous section. If the court finds that a person is not a person in need of custody or continued custody, the person is to be discharged from the custody of the commissioner. So if the court finds that a person doesn't meet those two statutory definitions, a person in need of custody, care, and habilitation, or a person in need of continued custody, care, and habilitation, the person will be discharged. And so the judicial order of discharge may be conditional or absolute, and may have an immediate or delayed effect. And then we move to, well, what about if the person is at a forensic facility? So in reviewing the placement of a person receiving treatment and programming at a forensic facility, the court may determine that while the placement at a forensic facility is no longer appropriate, or that the setting is no longer the least restrictive setting adequate to meet the person's needs, the person is still a person in need of continued custody, care, and habilitation. In that instance, the court is to discharge the person from placement at the forensic facility while maintaining the person's order of commitment or continued commitment. So what that is saying is that the court could make a finding that the forensic facility is no longer an appropriate placement for a person and discharge the person from the placement at a forensic facility, but the person is still in the custody of the Commissioner of Dale. They just might be moved to a less restrictive setting. And then in subdivision B, when a person is subject to judicial review pursuant to the subsection, is receiving treatment or programming at a forensic facility, either the state's attorney of the county where the person's prosecution originated, or the office of the Attorney General, if that office prosecuted the person's case, or the victim or both may intervene to provide a position as to whether the person's discharge from placement at the forensic facility is appropriate. And I know that Stuart flagged for me last night that he has a concern about this language, and I haven't had time to really look at it. But I think it might be a policy decision that the committee needs to make here.
Okay, so can you bring us back?
I will flag it in a future
different
draft.
legal opinions here, yes.
I don't know if there are different legal opinions at this point. Honestly,
are
haven't really had a
policies.
chance to let it soak in
Okay.
and review what he was articulating.
And we also, I have circled the word intervene and.
Yes.
Right,
Yeah.
which is a term of art.
Yeah.
And subsection C, so we had been talking about discharge by a court. A court is making a decision to discharge. Subsection C is discharge by the commissioner. So we have similar language and standards that if the commissioner determines that a person is no longer a person in need of custody or continued custody, the commissioner is to issue an administrative order for discharge of commitment. An administrative order for discharge from commitment may be conditional or absolute, have immediate or delayed effect. At least 10 days prior to the effective date of any administrative order for discharge by the commissioner from commitment, the commissioner shall give notice of pending discharge to the committing court and to either to the prosecutor, or the state's attorney, or the office of the Attorney General. And then we move into, well, what if we're not talking about commitment itself? What if we're talking about discharge from a forensic facility? So in reviewing placement of a person receiving treatment and programming in a forensic facility, the commissioner may determine that while placement in a forensic facility is no longer appropriate, setting is no longer least restrictive, the person is still a person in need of continued care and custody, then the commissioner can have the person discharged from the facility, but maintain custody of the person. So that's the same language that we looked at with regard to the court. And then we start moving into a lot of language that came to you from the House Judiciary. So when a person is subject to an administrative discharge, and that person is receiving treatment at a forensic facility, the prosecutor shall provide notice of the pending administrative discharge from placement at a forensic facility and commitment, if applicable, to any victim of the offense or the person for which the person has been charged who has not opted out of receiving notice. And then in B, if entitled to appear and call witnesses in the underlying criminal case, the state's attorney or the office of the attorney general or the victim or both may request a hearing on the person's pending administrative discharge from the person's placement at a forensic facility, which shall be heard 10 days after the request. Maybe that should be within 10 days.
Yeah.
Right there. Page 31. Heard within 10 days. Okay. Once the hearing is requested, the pending administrative discharge shall be stayed until the review of the court. And then this subsection D, this is what I went over with you earlier, where it had initially been drafted to be about discharge from commitment. Oh, sorry. So this is an old draft. The version that I walked through with you today changes the language about placement at a forensic facility.
Well, why don't we just
Pause there.
leave this draft, because we've been, and we'll, if you can put the two together, the language improvement that you've made.
You want me to pull that up?
No, we went through it once
Okay.
already. I'm just thinking that we can go through it again when we go through the bill next time,
Okay,
unless someone needs to go through it again.
got it.
Just a question, one more, the effective date. I think we heard some concerns about the effective date, given the
Well-
ability to get the facility ready.
Yes.
Did we already change it? Is this the
Yeah,
changed
yeah.
effective date?
Yes, but as I said, this was an arbitrary date that I
Okay.
pulled out of the air. So I did change it, and it's highlighted in your draft 3.1 to flag it for you, but this is meaningless besides it's 6 months after the original one.
Okay.
Yeah.
Okay. I guess that's more of a question for
Somebody-
Dale and DMH.
somebody
Will
out
they
there,
be
right,
ready?
Exactly.
Yeah.
The other question that I have is on the 90-day initial commitment
Okay.
for intellectual disabilities. Is that in here?
No, that you just asked me to,
Yeah.
right.
Okay. So we need to have those decision points around.
And I need clarity before I draft this.
Okay.
So it sounds like, you know, Stuart was bringing up the distinction between commitment and forensic facility, and we have timelines for both of those decisions. So when you're asking for 90 days for initial and up to 1 year for continued, like the mental health system, is that applying to commitment or is that applying to placement in a forensic facility or both?
Okay, I think this is a question that we need to discuss in here. If you're talking about up to 1 year, it might be more than a year with annual review. I mean, so there are different options within that for the initial commitment. And then the placement with an annual review. But initial placement of 90 days is what I was talking about.
Okay, so when I bring you language next, I will make this 90-day and 1 year, those timelines applicable only to placement at a forensic facility, and I will retain the language. No?
Oh, no,
Well,
I
'cause-
think, yeah. We have to think about that. I don't think we can answer that question right now. If it's an initial commitment for 90 days, is that parallel currently with DMH?
Yes.
So I'm thinking that for folks with intellectual disabilities, it should be comparable for the initial commitment
Okay,
and then the initial placement.
Can I ask a question?
Yeah.
Commitment, so I think you just said this when you were going over the draft, but just to be clear, commitment can continue even after somebody is not in the forensic facility. It could be commitment to a different kind of less restrictive facility. So the review, I at least would like to make sure there's ample review time and not having the indefinite language for both of them, that there's, you know, the ability
Yes,
to.
that's exactly what we're saying here, but we want to see that language, and then of course, we'll hear back from Dale and others that yes, no, but this was an issue that didn't, I think, get resolved. So
That's helpful.
Yes.
So I'm gonna repeat back what I think I heard. That
Uh-oh.
you, just to make sure I'm bringing the right language back. So that the 90-day and 1-year timeframes in the next draft will be applicable to commitment. And then for the forensic facility, I'll sort of use similar language that's in the draft now, that the term of a placement in the forensic facility couldn't be longer than the duration of the current order for commitment. Does that
Right.
sound accurate?
Right.
Okay.
Yeah.
That's
And
what
that
I'll do.
doesn't mean that doesn't mean that that's it, that means that that's what we want to.
You want
look
to
at.
see.
And I guess I would also like to hear from Dale or somebody with knowledge whether 1 year is appropriate as the
Well,
longer
that's
length
what,
of
that's
time.
that's exactly what we're doing. We're asking for folks. I see Rebecca shaking her head, yes, okay. And Stuart's out in the Zoom world along with Karen Barber, and they're the ones that will provide.
Well, I guess Stuart is the legal person. I want to know from the clinical perspective
Okay.
if a year is appropriate.
Sure.
Just because it's appropriate for mental health doesn't necessarily mean it's appropriate for.
And that is
intellectual.
exactly the point.
Yeah.
I have a rookie question, so I apologize, but difference between, or can someone please explain what the differences are between commitment and placement? Because I keep conflating the two in my mind.
Sure. So commitment is that the custody, that the person is in the custody of Dale. They could be placed in many different types of settings as appropriate for treatment. When we're talking about placement at a forensic facility, we're saying not only is the person committed to the custody of Dale, but this is where they're going to be receiving their treatment.
Okay, and so placement is only at play when it's around a forensic facility? Or can you use that
drafted
word
here.
for, okay.
Yeah, so as this is drafted, you're not having a court weigh in on the placement in the same way as you are for the forensic facility, having a specialized order from a court that this is the right placement. So this is sort of a new structure that you're setting up for placement at a forensic facility.
Thank you.
And just remember, decisions that we make here are gonna have a bit of a ways to go. Judiciary will be looking it over. They're not gonna, and then it will go to the House and be at least 2 committees that look at it there. So this is a work in progress. And it's a heavy lift for us. This is not an easy thing. And then Katie, there's language, is there language on that draft? I know I read the language on the competency restoration piece.
Yeah.
Maybe what I'll ask of the committee is to review that language. You want to do it really quick?
Sure.
Let's hold our questions on it. Let's look at it, and then we can come back to it.
Okay. So this is the new, so I'm in draft 5.1, if you're following along, this is the new section 15, and this is a reporting requirement.
Yeah.
And it's
What page?
30, great, thank you.
Right at the end.
And so this is requesting or directing by November 1st, AHS is reporting to various committees
It's online.
that provide a fiscal estimate, that a fiscal estimate is provided for the implementation of a competency restoration program that we've been sort of talking about and heard testimony on. That's either operated by DMH or DMH is contracting for the operation of that program. And then you have the elements that the analysis would include.
Yeah.
So like one piece is, in terms of the fiscal analysis, is who is eligible for competency restoration? What is that universe of individuals look like? What are the underlying charges that would be eligible for going into the competency restoration? That's going to impact the fiscal analysis. And then if you're also considering that, potentially there could be a residential facility that is where competency restoration would happen for people who are not in the custody of the Commissioner of Dale or in the Commissioner Dale DMH. So if these are individuals who are not needing that clinical level of care, they're not committed, but the court has ordered competency restoration. Where is that happening? So this asks for, if there's to be a facility where that's happening, keep that as part of the cost analysis.
And this is just for mental health competency restoration, correct?
No,
No, this could be somebody with intellectual
Anybody.
disability, this could be somebody with a mental health condition.
remember, we had the report, the 676, from 200, I don't know how many pages, it was a long report.
But it says that under Department of Mental Health.
The proposal that you've been hearing is that they would be responsible for operating the program. And if
For
I,
both populations?
I believe so, and if I have that wrong, I would welcome a correction.
Right, I think that was, we'll have to check that in the report, but, okay, so so look at this, and we'll come back to it, and go back and review the report that we received from DMH. We asked them in legislation last year, was it Act 27 also? Yes, that asked for competency restoration report.
I think that
was
was an Eric's
That was
bill, which I don't know.
Was the other bill.
The other bill.
Two
I
bills.
don't know that
always
number.
conflate the two bills. So we asked for that report. We had them in last time to talk about it. So now we are not in a position to suggest a competency restoration program in legislation. There's too much there. And so this was an opportunity to take it the next step without spending another 3 months sitting here doing it.
Can Kiki send us both the link to that report, about competency restoration, and also the working group report again? Just
I think they're all on our.
They are, but it would be
Yeah.
helpful if
Maybe
I could
put
have,
them up.
just having them in my email from you, Kiki, and then I would find it better. Thank you.
Put them up for today as well, so that they're there with this bill. That would be helpful.
Is it time to, thank you, is it time to make general comments on this bill, or are we not there yet?
We're not there yet. We need to go through it one more time.
Okay.
Yeah. Okay, and you can do that. I'm glad to have a conversation afterwards. Okay, so, thank you, Katie. This is a heavy lift on this one. Why don't we take a break until for 7 minutes, and then we'll come back and we'll hear testimony on 197. We're not done yet. We'll take testimony on 197 and go through the bill. So the testimony, I'm hoping, will be succinct, and then we can get through 197 again and make some decisions about the kind of changes we might like to make or not.